If you're in a family law dispute and already have a lawyer, pull up your contract and see if this is written anywhere on it. If it's not, you may be at a disadvantage. In 1997, the ISBA introduced Section 508F, which was done to entice small firms into handling family law cases. This may come as a surprise, but in family law, you generally can't pledge marital assets as collateral. So, if the client were to run up a ginormous bill and either refuses to pay or more likely can't pay, that lawyer often had to hire their own lawyer, file a separate lawsuit, and spend months or years litigating that unpaid bill. Back then, unless the client had deep pockets, most small firms and solo practitioners just simply stayed out of family law unless it was a large estate. And so it was no surprise a lot of dads back then were heavily pro se. 508F was the ISBA's grand bargain. If lawyers opted in, they could fast-track their bill to a judgment, and in return, clients got extra protections that others didn't, such as written mandates regarding communication, increased ability to challenge outrageous fees, and access to their file. Under case law, if you don't have a 508F contract, the attorney has the right to place a lien on your file if they withdraw due to non-payment. If your file had critical information in it relevant to your custody or financial dispute, and trial was tomorrow, you were sunk. But if you had a 508F contract, even if you owed the lawyer $1 billion, your right to your file was absolute. Today's case involves a file dispute. Now, the client was represented by the public defender. They're found guilty. Prior to sentencing, she hires a private lawyer who makes a demand for the file. The public defender curiously refuses, and the trial court upholds it. But the appellate court reverses, stating that she's entitled to most of the file, excluding possibly work product because that's like our private notes. And if there was a dispute over that, it'd be left up to the judge to decide. The reason why I wanted to highlight this case is this. If the lawyer wants to be difficult after they withdraw, they could hold your file hostage if you don't have a 508F disclosure attached to your contract. Another massive benefit for parents in 508F contracts is that it limits fee gouging. And take this non-508F contract, for example. It's from a well-known father's rights firm. It includes things that a 508F contract wouldn't dare have in it, like interest penalties for unpaid balances, excessive minimum billing, parking fees. Heck, you even got to pay this firm for quitting on you. In my opinion, if your contract doesn't have a 508F disclosure attached to it, you're really taking a huge risk if that professional relationship turns sour. Anyways, that's all I have. If you want more of these commentaries, hit that like or subscribe button because, hey, it's free.